Democratic AGs sue Trump admin to block Obamacare changes. What you need to know. Imagine a world where access to healthcare is deliberately made more difficult. That's the reality a group of Democratic attorneys general are fighting against, as they take legal action against the Trump administration's recent changes to the Affordable Care Act, ACA, also known as Obamacare. The coalition, led by California, Massachusetts, and New Jersey, filed a lawsuit in federal court to block the implementation of a rule they believe will severely undermine the healthcare law. But here's where it gets controversial. The Trump administration claims these changes are necessary to combat fraud, but the attorneys general argue that the true impact will be felt by millions of Americans who could lose their health insurance. Let's dive into the details. A coalition of 20 Democratic attorneys general took a stand on Thursday, suing the Trump administration to halt the implementation of a rule they believe will significantly weaken the Affordable Care Act. The lawsuit, filed in a federal court in Massachusetts, accuses the Department of Health and Human Services, HHS, of making illegal changes to the health law. These changes, according to the attorneys general, will make it more challenging for people to enroll in health care plans and will shift the financial burden onto states. The final rule, which was issued in June, proposes numerous amendments to the regulations governing federal and state health insurance marketplaces. The administration estimates that these changes could lead to nearly 2 million people losing their health insurance coverage. And this is the part most people miss. The attorneys general are seeking a court order to block specific portions of the rule from taking effect next month. In their complaint, they argue that the rule truncates and eliminates enrollment periods, makes enrollment more difficult, adds eligibility verification requirements, and erects unreasonable barriers to coverage. These changes, they claim, go far beyond the administration's stated goal of preventing fraudulent enrollment by insurance brokers and agents. One of the most contentious aspects of the rule is the exclusion of coverage for gender-affirming care as an essential health benefit. California Attorney General Rob Bonta criticized the administration's actions, stating, "Far from delivering on their promises to drive down costs and make America healthier, the Trump administration's HHS and CMS are doing their best to make it harder and more expensive for Americans to obtain health insurance and access care." The lawsuit argues that the rule is unlawful, arbitrary, and capricious, and that it would cause significant harm to states and their residents. The attorneys general contend that all the challenged marketplace changes implemented by the final rule will be detrimental to individual consumers and state and local governments. According to the Department of Health and Human Services, the final rule is designed to limit improper enrollments and the improper flow of federal funds. The administration projects that the rule could save up to $12 billion by 2026 by reining in wasteful federal spending and refocusing on making health insurance markets more affordable and sustainable for hardworking American families. But at what cost? The Attorney General's lawsuit raises important questions about the balance between preventing fraud and ensuring access to health care. As the legal battle unfolds, one thing is clear: the outcome will have significant implications for millions of Americans. So what do you think? Is the Trump administration's rule a necessary step to combat fraud? Or does it go too far in restricting access to health care? Share your thoughts in the comments below and let's discuss.